The idea of an independent executive agency, as with so many other unconstitutional ideas, goes back to the early 20th century. In the 1903 Supreme Court case Schertfeld versus United States, the court found, in the absence of constitutional or statutory provision, the president can, by virtue of his general power of appointment, remove an officer even though he were appointed by and with the advice and consent of the Senate. This power, assuming but not deciding that Congress could deprive the president of the right to exercise it in such a case as this, cannot be taken away by the mere inference or implication. In the absence of plain language in the statute, Congress will not be presumed to have taken it away. The fundamental flaw in the court's decision was assuming that Congress has the power to take away from the president his executive power. While there are many things that Congress can do with regards to the presidency, restricting his executive power is not one of them, since that power is established not by Congress, but by the Constitution of the United States. Then, in 1914, Congress created the Federal Trade Commission. Setting aside the question of the constitutionality of the FTC, Congress attempted to insulate the commission from the power of the president. Any commissioner may be removed by the president for inefficiency, neglect of duty, or malfeasance in office. Now, the power to execute laws is not vested in Congress, but solely in the president. So Congress does not have the constitutional authority to tell the president how to exercise his executive power, only to punish him for any high crimes or misdemeanors he may commit. Remember, Congress makes the law and the president executes them, but those laws must be made in pursuant to the Constitution to be the supreme law of the land. As we read from Article 6, Clause 2, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. So when Congress passes a law that infringes on the constitutional power of the presidency, if that law is not made pursuant to the Constitution, it's not only not the supreme law of the land, but as Alexander Hamilton put it in Federalist 78, it's void. There is no disposition which depends on clear principles, that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid.